Firstly, on behalf of Ethical, thank you very much for the opportunity to be here. I think it's a privilege for us to be able to attend this webinar and share some of our experiences and share some of our thoughts on the topic of consent. Without further ado, I'll go ahead. But I think the point for me in this talk is to try and make it as practical as possible. So the topics that I'd like to cover are quite rudimentary. The first one is, why is it necessary to have consent, and what is it? What does our law say? And here I'll talk about the 3 requirements for consent, specifically capacity, knowledge or information, and the 3rd requirement is voluntary or agreement. And we'll touch on each of them because it's quite important. And then what are the consequences of not taking consent? Informed refusal is obviously a big issue. Withdrawal of consent, and when is consent not required? Obviously, this refers to emergency situations. And then lastly, I'll take you through some practical tips with regard to your consent forms. As I mentioned, we've put together a 1-page document that will be shared with you, but as a disclaimer, it's not a comprehensive document. It's merely intended to be a guideline, and when necessary, you should seek professional assistance for your particular circumstances. So coming to the first point here, sorry, I just need to change my screen. What is consent, and why is it necessary? But I think the way that I'd like to deal with this is a bit different, to give you a sense of what we deal with as lawyers or people that are confronted with a claim down the line. So in the context where informed consent is being scrutinized because there's now a claim, a civil claim, often complications come into being. So
it went exactly as long as it was supposed to in order to get it done right.
So there were no complications?
I don't have complications.
Every doctor has complications.
Not me.
For those of you that don't know, this was a clip taken from a series called Dr. Death. And it had to do with the real life story of Dr. Christopher Dench, who was a former American neurosurgeon who was nicknamed Dr. Death for gross malpractice resulting in the maiming of several of his patients' spines and 2 deaths. Now, the words that he emphasizes that he doesn't have complications, I think is a chilling one, because I think the reality is that we all accept that complications do happen. It's part and parcel of medicine. No matter how careful the surgeons are, no matter how many years experience you have, you can always have complications. And that's really, for me, the crux of where, as a lawyer, informed consent comes in, because it's typically that scenario that manifests into a claim. Whether it's cranial or spinal procedures that you are dealing with some of the most delicate structures of your body, the brain, spinal cord, nerves, and there are a multitude of different types of complications that can occur. Complications such as brain edemas, seizures, post-operative hemorrhage, cerebrospinal fluid leaks, elevated intracranial pressure. These are part and parcel of everyday life for you. But for a patient, it's not. And for a patient to understand that complications can occur is really the heart of what's expected when it comes to informed consent. Complications happen frequently, but probably the most common complications that we see is that the surgery doesn't do what was expected. In other words, for example, removing the pain. Now that's considered to be a complication because it didn't have the desired outcome. Another complication that's common is infection. You're opening up a body, you're busy for hours inside a body, using all sorts of instruments, putting in rods, screws, other materials. And no matter how much precaution you take, it's relatively common to have infections. So sometimes you need to go back inside and clean it up with antibiotics, or you experience a situation where there's some cerebrospinal fluid leakage. But for a patient, this is very unusual. And again, this comes back to the issue of what happens when there's a complication. If it's an unexpected outcome, it could lead to subsequent anger on the part of the patient. And if you don't dispel certain unrealistic expectations concerning the treatment, you may face a claim to the HPCSA, a suit for civil damages, or even worse, criminal liability for culpable homicide. So situations frequently arise in clinical negligence cases where the outcome of the case hinges on the informed consent process. So good patient education during the consent process is the surgeon's chance to make sure that the patient's expectations are realistic, and a proper understanding of the informed consent process is probably the most effective way to manage your risk. Another thing to keep in mind is that when we talk about informed consent, I prefer to use the term informed decision-making, because that's really what it is. And I often tell doctors that it's not simply the signature of a form. It's much more than that. A signature on a consent form without a balanced discussion does not constitute informed consent. And we've seen it in multiple court judgments. Therefore, the process is best described as informed decision-making. In South Africa, the manner in which you convey certain information to a patient is of cardinal importance, all the more so because of the diversity in this country of cultural, racial, socioeconomic, language, and educational differences. So the onus is on you as the practitioner to ensure that not only enough information has been imparted, but also that the patient has a good understanding of all the relevant implications and risks. Now, obviously the question is, well, how much information do you share with him? It's therefore preferable and advisable for the practitioner, without being condescending or paternalistic, to underestimate rather than overestimate the patient's intelligence and comprehension of what's being imparted. You're dealing with highly technical, complex clinical issues, and not all patients would have an understanding as to what's going on. So for that reason, it's very important that when a patient has difficulty understanding information, the practitioner must have the patience and care to repeat and try to use as little medical jargon as possible and in non-technical terms. Now, the practitioner is also obliged to explain the procedure or treatment until he or she is satisfied that the patient, or in some cases their family, understands the procedure and its possible consequences and outcomes. And again, another thing that I tell practitioners is that is really where your expertise as an expert comes in. You are the experts of your craft, and that requires intuition. No matter how many guidelines or talks I can give, ultimately it's you in that discussion with the patient or their family. So you need to use your intuition to understand where that patient is coming from, based on the question they're asking you, based on the clinical history you're taking. It really boils down to that intuition. Coming back to some of the requirements or why consent is necessary. Now, you might remember some time ago, my colleague, Dr. Shombe Makaluma from Ethical, gave a talk on medical malpractice claims in neurosurgery. And one of the slides, he mentioned that there are 5 requirements for a plaintiff to meet in order to sustain a delictual cause of action, what we call sometimes in international law, tort liability. So there's 5 requirements. So you'll often hear advocates, judges talking about those 5 requirements in order to sustain a cause of action. So in other words, there must be an act which is wrongful and negligent that has caused damage to the patient. Once you prove all those 5 things, then you come out with this delictual liability. Now, where informed consent comes in is that it's the absence of wrongfulness. So in other words, consent is a valid ground of justification. So in other words, there's an absence of wrongfulness when you take proper informed consent. So in other words, if there's no informed consent, then a doctor's treatment is wrongful, and he will be liable to the patient indeed if his wrongful conduct was perpetuated with fault and caused the harm of which the patient complains. What does our law say? For this purpose, I'm not going to dwell too much on case law and what some of the pieces of legislation says. I'm really going to highlight a few things, and I think it's things that you probably are aware of or ought to know. The first thing is that both in this 1923 case as well as Section 12 of the Constitution entrenches the principle that the rights of patient autonomy and bodily protection is of utmost importance. So all your patients have that right, and that's a constitutional imperative that we have to respect those rights of patient autonomy. Section 6 of the National Health Act is applicable. It states that every doctor must inform a patient of the range of treatment options available, the benefits, risks, and costs and consequences generally associated with each option. Now, I want to pause here because it's important to highlight that informed consent consists of two main elements. The first is the treatment options that I think everybody understands. You need to convey all the options, the benefits, risks, complications, consequences, all those things. But the second important element is the financial issue or the cost component. That's another issue relating to consent. That's what we call financial consent. Now, why it's relevant is because we often see in the context of HPCSA complaints that most of the complaints relate to this aspect that's overlooked. Now, Section 53, 1B of the Health Professions Act stipulates that if a patient asks you, you must tell him or her what fee is you intend charging. And if your fee exceeds what is usually charged in such an event, you must tell them what the usual fee is. Now, it's not very helpful, but in the absence of a published tariff, and given the current controversy surrounding this, you should advise the patient to seek information concerning what other practitioners may charge for the same treatment. And later down the line, when we talk about some of the practical tips, I'll give you some guidance as to how to deal with that particular issue. The HPCSA ethical guidelines, here booklet 4 is relevant. The National Patients Health Charter also says that it's no longer a process of submission. In other words, consent. Every person has the right to participate in decision-making on matters affecting their health. When in doubt, I would advocate that you take some time to have a look at booklet 4. It's very comprehensive. It's quite useful and it's easily readable. Now, coming to the meat of what we're dealing with. There's a case that took place in 1994, in fact, earlier than that, but it really was the first case in South Africa that dealt with the doctrine of informed consent. A patient sued a plastic surgeon after her double mastectomy. It was held that the plastic surgeon had not disclosed the risks involved with a mastectomy, and had the patient known of the inherent risks of the procedure, she would not have undergone the procedure. So ultimately, there were 4 principles that the court enunciated. The first is that the consenting party must have had knowledge and been aware of the nature and extent of the harm or risk. Number 2, the consenting party must have appreciated and understood the nature and extent of the harm or the risk. Number 3, the consenting party must have consented to the harm or assumed the risk. And lastly, the consent must be comprehensive. That is, extend to the entire transaction inclusive of its consequences. Now, to sum up, the 3 requirements are the following. Capacity. Sorry, these slides are just delayed. So there are 3 requirements that basically came out of that decision. And those are the 3 requirements that you have to meet in order to sustain a proper informed consent as a basis for your defense if you are challenged on that. So firstly, the patient must have given sufficient information or knowledge in a way that they can understand or appreciate to enable them to exercise their right to make informed decisions about their healthcare. All 3 are required. So for example, if one of them are not there, for example, if consent can be vitiated if a patient is not given sufficient information to enable them to provide consent. Now let's look at each of those requirements. First, capacity to consent. And in your field of work, I'm sure that these are the two most important topics, first relating to minors and then secondly relating to mentally incapacitated patients. Now, Section 129 of the Children's Act is applicable here. And to break it down in its most basic form, what the Act tries to do is it tries to take a vulnerable member of society and put into place certain requirements that ensures that the best interest of the child is protected and looked after. So that's why there's quite a bit involved here. But in essence, you must assess a child's capacity to decide whether to consent to or refuse a proposed investigation or treatment before you provide it. Generally, a competent child will be able to understand the nature, purpose, and possible consequences of the proposed investigation or treatment, as well as the consequences of non-treatment. Your assessment must take into account the following. A child who is 12 years of age is legally competent to consent to medical treatment if the child is of a sufficient maturity and has the mental capacity to understand the benefits, risks, and other implications of the treatment. Where the child is under 12 years of age or not of sufficient maturity and does not have the necessary mental capacity, his or her parent, guardian, or caregiver must give consent to medical treatment. Turning to surgical operations, a child who is 12 years of age is legally competent to consent to a surgical operation if the child is of sufficient maturity, has the mental capacity to understand the benefits, risks, and other implications of the surgical operation, and is duly assisted by his or her parent or guardian. Now, when a child is under 12 years of age or not of sufficient maturity and does not have the necessary mental capacity, his or her parent or guardian may give consent to the surgical procedure. Now, there are obviously other mechanisms that, if none of them are available or none of them are applicable, the superintendent of a hospital or the person in charge of the hospital, in the absence of the superintendent, can give the necessary consent if it's necessary to preserve the life of the child or to save the child from serious or lasting physical injury or disability. Next in that chain, you have the Minister of Health who may consent if the parent or guardian of the child unreasonably refuses to give consent, or if the child unreasonably refuses to give their consent. And then lastly, a high court or a children's court, and the children's court is usually a special court situated within a magisterial district. A court may grant consent to the medical treatment or the surgical operation on a child in all instances where another person that may give consent refuses or is unable to give consent. You often hear that the High Court is the upper guardian of children, and that's basically the catch-all for this particular instance. No parent, guardian, or caregiver of a child may refuse to assist the child or withhold consent by reason only of religious or other beliefs, unless the parent or guardian can show that there is a medically accepted alternative choice to the medical treatment. Turning to mentally incapacitated patients. Now here the Mental Health Care Act is applicable. You must always work on the presumption that every adult has the capacity to decide whether to consent to or refuse proposed medical intervention, unless it is shown that they cannot understand information presented in a clear way. The question is, how do you do that? Well, if a patient's choice appears to be irrational or does not accord with your view of what is in the patient's best interest, this is not evidence in itself that the patient lacks competence. In such circumstances, it may be appropriate to review the patient with the patient whether all reasonable steps have been taken to identify and meet their information needs. Now, where you need to assess a patient's capacity, you can make that decision after considering guidance, either going to a professional body or consulting with colleagues. And my suggestion is always that when you do consult with another body or with your colleagues, to follow the ethical guidelines set out in the HPCSA booklet. In other words, when you work through the ethical decision-making, always jot down your clinical approach or your ethical decision-making thought process in your records. The National Health Act makes provision for certain persons to consent on behalf of mentally incompetent patients to an operation or medical treatment, where such patients are unable to give the necessary consent and have not mandated, while still mentally competent, somebody else in writing to give consent on their behalf. So the Act sets out a priority list of persons who may consent. First, a person authorized by the court, in that case it would be a curator, and secondly, in order of priority, the patient's spouse, then partner, then parent, then grandparent, then major child, or brother or sister. Provision is also made in the Mental Health Care Act for consent to be given on behalf of persons who are mentally ill by another competent person. Now, let's talk quickly about advanced directives. Advanced directives are instructions given by patients regarding their future treatment, should they become incompetent to consent to or refuse such treatment, where a directive authorizes a third person or a proxy to give consent. Such person impliedly also has the authority to refuse consent. Now, the National Health Act makes provision for mandated consent by proxy. So the Act provides a mechanism where patients may mandate a person in writing, and that's important, it must be in writing, to consent to a health service on their behalf when they are unable to give such consent. Now the question is, does that mandated consent by proxy apply to patients who become permanently mentally incompetent? So where the patient was mentally competent at the time that he or she mandated the proxy in writing to consent to treatment on his or her behalf, the National Health Act is clear. The mandated proxy consent prevails. No formalities are required other than that the mandate must be in writing. It would be prudent, however, to have the mandate dated and signed by the patient with 2 witnesses. And also it would be useful to capture that in your records as well. The HPCSA states that where a patient lacks the capacity to decide, healthcare practitioners must respect any valid advanced refusal or treatment. It further recommends encouraging patients with terminal conditions to appoint a proxy to make decisions on their behalf in the event of their losing decisional capacity. If there's any doubt about the validity or applicability of an advanced decision or directive, for example, there's reason to believe that the patient may have changed their mind since drawing up the directive, or the current circumstances do not correspond with those specified in the directive, the patient should then be provided with care to secure his or her best interests while the issue is resolved, if necessary by reference to the courts. And then lastly, the National Health Act provides an effective way for patients who may become mentally incompetent during or as a result of a health service to appoint proxies to make decisions on their behalf. All that is required is that the mandate must be in writing and that he or she executes it. Such proxy mandates take precedence over the wishes of relatives or partners and are binding, whether the patient is temporarily or permanently unable to give consent unless a court orders otherwise. Now, we dealt with capacity. Let's look at information, which is the second requirement for proper consent. And here the issue relates to how much information is necessary to convey to a patient. And you'll often hear the phrase material risks. So you must give patients any information that they want or need about the potential risks, including the well-established complications of the procedure and any risk of serious harm, however unlikely it is to occur. You must also answer any questions they have honestly and openly. Now, the law requires that you take reasonable care to explain to patients any material risks involved in recommending treatment and of any reasonable alternative treatment, including no treatment, if appropriate. Now, the phrase material risks has a particular connotation in the legal sense. It refers to those risks that a reasonable person in the patient's position would likely attach significance to. So, for example, if someone was a professional pianist and a procedure entailed amputating their arm, that's clearly something that would be of significance or that would attach real significance to that person. Not that amputation wouldn't be important for anyone else, but in the case of a pianist, it might be even more important where they wouldn't want to amputate. Then fundamentally, explaining risk is all about meaningful dialogue, the exchange of relevant information specific to the individual patient to enable them to make an informed choice based on what matters to them. There's no standard one-size-fits-all. As I mentioned, it's a matter of intuition based on the clinical history that you take, what's really important to that patient, and what the circumstances entail. I'm just going to highlight one or two decisions from some old case law that makes it clear that not all information is necessary. In the case of Richter and another versus Estate Hamann, it involved a patient who was paralyzed as a result of a right-sided phenol block of the lower sacral nerves. The patient had injured her coccyx for the second time when she fell on a sharp edge of a chair. She consulted a neurosurgeon, an epidural block having failed. The doctor suggested bilateral phenol blocks of the lower sacral nerves. The right-sided block was performed first, the intention being to administer the second 2 days later. However, something went awry and the claimant was left in a partially paralyzed state. Now, the judge dismissed the action on all the grounds and concluded that the neurosurgeon's decision to recommend the phenol blocks was above criticism. But of note, what he said there was that what a reasonable doctor, having regard to all the circumstances of the particular case, should or shouldn't do is of the utmost importance when a court comes to that conclusion. Another case, and quite an old decision, but just emphasizing that there's no expectation that the surgeon must point out all the complications that may arise. Agreement, which is the third and last requirement of proper consent. I think this is quite uncontroversial. Consent must be provided voluntarily without any undue coercion. It must not be influenced by the doctor or their family. Doctors are only to advise and provide the relevant information, and patient autonomy must always be respected. Consequences of failing to obtain informed consent. Usually this creeps up in the situation where there's litigation and the central issue is whether or not there was informed consent. Now, it could be dealt with in a number of ways. You could have a situation where there's written consent, but the consent itself, or what's listed in the written document, is insufficient, or there's simply only oral evidence constituting the informed consent process, which makes it much more difficult to prove. And then lastly, implied consent, which is the least legally substantiated. Now, it's best to avoid, where possible, the implied consent. Healthcare practitioners should be careful about relying on a patient's apparent compliance with the procedure as a form of consent. Submission in itself may not necessarily indicate consent. For example, the fact that a patient lays down on an examination couch does not indicate that the patient has understood what you propose to do and why. Consent must at all times be expressed and not implied. So what are the consequences of not having proper consent? Firstly, there's an inability to prove consent if there's no written documentation. And what it boils down to is that in a court of law, it becomes a he said, she said issue. So really it's dependent on the factual testimony of witnesses, recollection, memory, available documentation. So even if there's no written consent form, the court will scrutinize your medical records. Too often, reliance is placed on the proof of informed consent obtained by the hospital staff. We often see it in the course of our review of cases where you ask for the informed consent document and then you get a confirmation of consent, which has got all the hospital logos on there. Unfortunately, that is not constituted as proper consent or written consent. That is simply a confirmation that consent was taken. But that in itself is not sufficient because, for example, it might not necessarily list any of the complications or that certain things have been discussed with patients. So it's often not very helpful. What happens if a patient alleges that there was no consent? Well, practically the court will adjudicate on whether there was proper consent. The documentation will be reviewed, consent will be looked at as evidence. It'll be scrutinized in conjunction with your records. So who's responsible for obtaining consent? The doctor undertaking an investigation or providing treatment should usually talk to the patient, but may decide to delegate part of the decision-making process to someone in the healthcare team who is suitably trained and competent. However, the doctor must ensure that the person they delegate to has sufficient knowledge of the intervention and its associated benefits and harms, as well as alternative options for treatment and care. They must also possess the skills to have a dialogue with the patient in accordance with the HPCSA guidance. If part of the decision-making process has been delegated, the treating doctor is still responsible for making sure the patient has been given the information they need to make a decision, has had time and support to consider it, and has given their consent before the treatment is provided. The right to refuse treatment, informed refusal. So once a person of full legal capacity refuses treatment, say for a few exceptional cases, that person cannot be forced to undergo medical treatment. In line with the emphasis on patient autonomy, it applies irrespective of whether the doctor is of the opinion that it would be the most beneficial for the patient to undergo the treatment recommended. In fact, the patient is entitled and empowered to refuse medical treatment, no matter how ill-advised such a refusal might be, and no matter how dire or permanent the consequences may turn out to be. Any person who is capable to consent has the capacity to refuse treatment. Now, the recommendation is when you're confronted with a situation like this is to discuss and document the following: your recommendations of tests, investigations, and treatments, including alternatives and their importance to the patient's health, the potential clinical consequences of non-compliance or refusal, any occurrences of patient missing appointments, cancellations, and failures to undergo diagnostic tests, all factors that may be contributing to refusal or non-compliance and the steps taken to address them should also be documented. In the final decision, it is not to follow the recommended care or treatment plan. The consultation should include a discussion about the next appropriate steps. Now, that could also be a discussion about that you may wish to consider withdrawing from the patient's care. Withdrawal from consent. Every patient has the right to withdraw consent at any time. So it's important to realize that consent can be repealed, withdrawn freely at any stage, whether it's before or during the treatment or procedure. When a patient does withdraw, it is assumed that the consent was never given in the first place. It therefore follows that as soon as consent is withdrawn, the treatment or procedure, if started, must be stopped immediately. Should the practitioner persist in the performance of the treatment or procedure, he or she will be liable in delict if no justification was present. When consent may not be required. Now, this refers to emergency situations. This is just a reference to Rule 27, capital A from the HPCSA guidelines. But ultimately, when it comes to emergency situations, the general rule is that informed consent must be obtained from a patient who is in full possession of his or her faculties before a surgical procedure or other medical treatment is rendered. But emergency situations is one of the exceptions to that. Or owing to unconsciousness, the delirium, shock, or coma arising from drunkenness or an accident, it's impossible to obtain the patient's consent because a lack of capacity. But also to consent to a medical intervention which might be necessary in the circumstance. It's necessary in order to save his or her life or to preserve his or her health. The defense of unauthorized administration may come to the rescue of the practitioner who in fact performs the surgery or provides the treatment required in the circumstances. So there are a couple of requirements that must be met. Firstly, the situation must be an emergency which necessitates the intervention. In other words, there must be an immediate threat to the patient's life or health. which renders delaying the intervention until such time as the patient is in a position to consent impossible. The patient must be incapable of consenting to or unaware of the intervention. The intervention must not be expressly prohibited or against the patient's will. The intervention must be intended to be in the patient's best interest. However, you must respect the terms of any valid advance refusal by the patient which you know about or which is drawn to your attention. After the emergency, you should tell the patient what you have done and why as soon as the patient is sufficiently recovered to understand. Now let's look at some of the practical tips. So generally, I see informed consent or informed decision-making in 4 steps. Introductions, explaining the procedure and material risks, explaining the costs, and then lastly, taking the actual consent. Now, this is just one proposed way of doing it. I know many practitioners have their own way of doing it, and what works for them is often fine. And as I mentioned right in the beginning, it's really a matter of intuition. It's a discussion, it's an ongoing discussion or a process of discussion between you and the patient. So as part of the introduction, it's a matter of explaining the condition, using simple language, etc. But I'll touch on each of them as I go on. So the first step is the initial introductions. Try to obtain informed consent in the manner that you would like to be treated if you were the patient. Taking down a careful history and taking time to listen to the patient, combined with a proper examination, are essential for a correct diagnosis. This is, in fact, what the patient came for. Explaining the diagnosis is the first step towards taking informed consent. For that purpose, it is useful to have pictures, models, or other anatomical drawings. Even making simple drawings on a piece of paper to explain the exact nature of the problem. Making the patient understands this is essential before explaining the treatment alternatives in lay terms. As I mentioned, use simple language in explaining the condition, assess your patient's capacity to understand the information, avoid technical medical terminology, otherwise use a glossary and attach that to the consent form. Utilize an interpreter when necessary for the informed consent discussion, because there may be a misunderstanding when it comes to certain topics or concepts. A patient's questions or obvious lack of understanding about the procedure should be addressed by you as soon as possible. Obtaining consent from the patient after a sedative or sleep-inducing medication is administered is not recommended. However, when a change in the patient's condition requires a change in treatment, secure the patient's consent. Document the medical records thoroughly with the facts and conditions surrounding the need for the revised consent. And just before I forget, often you have situations where members of the family are accompanying a patient. It's also useful to document that as well in your notes. Step 2, explain the procedure and the material risks. So here it's required that you discuss the various options available to the patient for treatment, including non-operative care and no treatment, together with the potential benefits and risks of each option. So as I mentioned, use anatomical drawings, attach that to the consent form, discuss, recognize, and material complications. Consent should be obtained for treatment of any specific problems that may emerge during the surgery. So for example, unforeseen conditions that may be discovered that may necessitate additional procedures. Also, if a patient has specified that they would rather a procedure didn't go ahead in the event of certain clinical findings, the patient's decision must be recorded and respected. Discuss potential follow-up treatment, allow an opportunity for questions and answers, provide further sources of patient information, whether it's a link to a website or recognize incredible patient leaflets or other documentation that they can consult. Invite the patient to contact you if additional questions arise. And for that reason, it's useful to have your contact details on your consent forms. Use the repeat back or teach back method. That's just one method that I know some practitioners use, where after a brief discussion in layman's terms, they often ask the patient to repeat back just to gauge whether there is some sort of understanding. But that's just one tool. If you have not explained to the patient that a certain situation may arise and the options for continuing in this eventuality are not fully described, you should not perform the procedure unless it is an emergency. If you took consent for any endoscopy or keyhole technique, you must inform the patient of the possibility of an open procedure. This should be a standard part of the consent. No guarantees or promises should be made regarding the outcomes of the procedure, and the patient has the right to refuse the procedure. The patient is to be informed of the consequences of refusal as well. Information about the team, whether there's an anesthetist, surgical assistant, etc., because patients have the right to choose their healthcare providers. Step number 3 relates to the costs. When it comes to obtaining the patient's informed financial consent, similar considerations apply as relating to the normal treatment. Here again, it's an exchange of information, and it's important to document so that you're able to show that the patient was given all the information. What you should give patients is to ensure as far as possible that they have enough information to consent to the cost of the proposed treatment or procedure. Examples of this could include advising the patient, if appropriate, that you contract with them only, regardless of their membership of a particular medical aid scheme or benefit organization. Warn patients that what their medical aid scheme is likely to pay for any particular treatment modality is a matter between their scheme and them, and it is not within your control, unless, of course, you have an arrangement or an agreement with the scheme. The controversy surrounding published rates is unlikely to be resolved soon, so tell your patients what you intend to charge with reference to, wherever possible, a fixed rand amount, particularly if they ask. Warn patients that additional costs may be incurred if, for example, complications are encountered. That's always a great source of tension for patients when there's a complication, not necessarily the complication, but the fact that now they have to incur these additional costs. So it's obviously good to manage their expectations if there's a likelihood of certain complications. Step 4 is the actual taking of the consent. So the suggestion is to have or develop procedure-specific forms that the patient can sign when the informed consent discussion takes place. If possible, translate those consent forms to the most common non-English languages that you encounter in your practice and verify that the form is translated correctly. Some of the things that you should include seems quite obvious, but the full name of the patient, your name and contact details, the condition, treatment options, material complications, and again, I must stress what was stated in that old court case decision is that it's not every single complication, but only those complications that you think the patient would find material or of significance. Document the procedure, the date and time of the procedure, and any reference information, resources, or anatomical drawings that you might have referred to as part of the discussion. If it's available, attach it or use the reference to the website or the YouTube clip or whatever it may be. Confirmation that the patient understands and has asked questions, that financial consent has been given, and then the use of blood products or anesthesia. Additions or corrections to the consent form must be dated, timed, and stamped or signed by both parties. Any member of the healthcare team may sign as a witness to the patient's signature, although this serves only to verify that it was the patient who signed the form. The witness does not obtain consent or verify the patient's competency to give consent. And lastly, don't forget, document the discussion in your records and who accompanied the patient. In some cases, the consent form itself might be lost, stolen, destroyed for whatever reason, but at least if there's some confirmation in your actual records that that discussion took place, it does go a long way to assist you. And then lastly, as a last final practical suggestion, if you don't know about this website, the Australian government has a website where very good informed consent forms are available, and it's a free website. You'll see it's the Queensland informed consent forms. I know some practitioners do use it, but for those of you that don't or haven't developed your own, this is a very good starting point, and I would urge you to consider or at least have a look. Whether it's cervical laminectomy, craniotomies, lumbar decompression, and pedicle screw fusions, they've got a wide range of procedure-specific consent forms. I'm sorry if I went over the time. It was quite difficult to fit all of this in the time allocated, but happy to take any questions. Thank you very much.